the national and international laws. So those people include the leaders of the Pol Pot regime and people who were most responsible for the crimes and grave breaches of national and international laws. Altogether, there are only 14 people. Among them, Kaing is not listed. Although recently, Kaing alias Duch admitted or confessed he committed the crimes. However, as the lawyer for him, I have to fight for justice for him and for people who died and those who survived the regime. So if anyone other than these 14 people is prosecuted, it is violating the law on the agreement or the law on the establishment of the ECCC, because in the law it states clearly that the court is or has the jurisdiction to only try those most senior and most responsible people who have committed the crimes and grave breaches of international law. So there are only 14 of them. And trying only some among the 14, the question is that how can justice be done, and how can the dead people and the victims or the people who survived accept this? And number 4, when Duch is only prosecuted, is it legal? Is it justified? Because in the Democratic Cambodia regime, there are 196 prisons. And so far as I observed, in Ba Phnom Prewang province, the prison in their province were not included, because there were some prisons also in that province. So there would have been more than 200 prisons. The people who were arrested and detained at the prisons, the chief of the prison had the same role and responsibility as the chairperson at S21 was asked to do. First, they were asked to make sure that the people who were arrested could not escape. And number 2, those who were brought in must be taken confession. And the confession must be taken by way of torture to draw the confession whether the person being CIA or KGB or the Vietnamese spies. Number 4, torture were inflicted in all prisons across the country. First, the practice of torture is called a cool approach. If the person failed to confess, then he would be inflicted what we call the hot approach, followed by chewing approach.
So after the confessions were done, then they need to be executed. That is the duties in each prison. Therefore, if Duch is only prosecuted, all those chiefs of the 196 prisons chiefs needs to be prosecuted as well. And who are above those prison chiefs? They have to be arrested and bring for trial as well, because they are above the chiefs of the prisons. And that is called justice and fair. Because Article 31 of the Constitution of the Kingdom of Cambodia stated clearly that the Cambodian people has equal right before the law. And now, is it fair? Because each prison receives the same orders from the same Angka, and each prison also conducted torture, executions. And why only Duch is brought for trial? And only Duch is the only scapegoat on behalf of those 195 chiefs of prisons. Is this called justice of the ECCC with the UN involvement? Therefore, the prosecution of Duch alone, without taking into consideration 195 prison chiefs, is a decision in contradictory to the constitution of the Kingdom of Cambodia on the Article 31, and this is the violations of the sovereignty, because this trial is to respect the sovereignty of the Kingdom of Cambodia. According to the third purpose of the government of Cambodia, the prosecution needs to respect the sovereignty. But now the Cambodian sovereignty is violated. If they do not obey Article 31 of the Constitution of Cambodia, it is a violation. Your Honours need to consider this. So the defense counsel, can accept it. And I would like the co-prosecutors to reconsider this request. You are the one who bear the burden on the prosecutions and needs to explain to the chamber why only Duch is brought for trial and not all those 195 chiefs of prisons. And why not those above the chiefs of prisons to be brought for trial and prosecuted and explained to the chamber before Duch is put in prison? As I said again, to prosecute Duch alone, if he is the senior leader of the Democratic Cambodia or the most responsible for the crimes and the serious breaches of both national and international laws, then it needs to be clarified. The co-prosecutors need to explain to the chamber whether Duch is a senior leader or the most responsible. What documents to prove? Because the lawyers, I have the documents, only the 14 people who were the senior leaders, and if the co-prosecutors have such documents to prove, or what evidence they have, or it's only just by their words of mouth from them, it needs to be clarified. 5. On the 196 prisons, those 196 prisons, 132 prisons had no figures of the killings. And only some prisons, for example, in Posan province, in Liech area, but there was no concrete figure. And only 64 prisons had clear numbers of those killed. And so, amongst the 64 who had the numbers of people killed, S21 is number 10 amongst those 64 prisons. S21 listed as number 10 only. So if S21 is taken to compare to Chong Churoi prison in Cheu Trach village in Relief Ear, Kampong Chnang province, in that province, 150,000 people were killed in that prison. It means 10 times the number of those killed in S21 is not even equal to that number yet. So why can the co-prosecutors inform the chambers why is such a case? And I would like to request the chamber's permission to express that I do not demand that the 196 chiefs of prisons or the 64 chiefs of prisons need to be brought for trial, but I just don't want this to be just a scapegoat. And I want all of you to consider the scope of the risk of the damages and of the tragedy and the scale of the crimes between those who died, of the 12,000 people plus who died in S21 and the 150,000 who died at Chong Churoi prison. If 150,000 people die in Chong Churoi and not prosecuted, and only the 12,380 prosecute at S21 and he's brought for prosecution, this is not right. This is not a justice. And it's not in accordance with the Article 31 of the Constitution of the Kingdom of Cambodia. Because Cambodian people has equal rights before the law. Then it needs to be done in general, not selectively. Because each prison has those who died there. If you prosecute them all. Otherwise, do not prosecute them at all. They are the same. They are chiefs of prison. And people were killed too. And if 195 chiefs are not prosecuted, and only Duch is prosecuted, there is no justice. So the co-prosecutors need to justify this to the trial chamber. Moreover, the second purpose of the royal government of Cambodia in the prosecution is for the regime not to return or to exist again in the Kingdom of Cambodia. And if only some of those who killed some people are prosecuted, and those who then the regime might return. Or it means more people need to be killed in order not to be prosecuted. As in this case of Duch. Why Duch was imprisoned? Is it because he killed less people? This is the lesson. S21 is a special prison. As in the indictment, it has a special characteristic. The specialty is that it killed less people and it is being prosecuted, and those who kill more are not being prosecuted. And so, to prosecute Duch alone is the second violation of Cambodia, as well as the violations of Article 31 of the Constitution of the Kingdom of Cambodia, as well as the violations of Article 1 of the law on the establishment of the ECCC, because Duch is not a senior leader or the most responsible for the crimes. Another point I would like to raise with your honor's leave is number 6. In response to the brief statement of the co-prosecutors that the Vietnamese troops and the Vietnamese civilians who were arrested and sent to Tuol Sleng were killed by S-21, and allegedly that S-21 involved with the prisoners of war. I would like the trial chamber to take this matter into account. The Vietnamese civilians in Cambodia at the time. So if you splash the water to each other, it's going to stain each other. And don't you think that the Khmer soldiers and civilians were killed by the Vietnamese as well? If they kill each other like that, and why the Vietnamese side doesn't commit any war crimes? So I would like the trial chamber to consider this matter in order to find justice. Point number 7. I have seen that the crimes committed at S-21, Duch did not deny it, and he has been cooperating with the court. Whatever the co-prosecutors raised, Duch accepted it with both hands. However, according to the law, to prosecute Duch alone, is it fair compared to other 195 chiefs of prisons? So this is a question that needs to be resolved. Another point. Madam Co-Prosecutor this morning said this prosecution is for the humankind to learn as a lesson. But the humankind is not only for the Cambodian people but also for the international community. How can it be learned as a lesson? Because those who kill less is being prosecuted and those who kill more is not being prosecuted. That needs to be considered. In addition, the international co-lawyer, Mr. Robert Petit, said the theory of the joint criminal enterprise shall be implemented and exercised for the S21 crimes. I do not deny to that. Please go ahead. However, it needs to be exercised for all those 190. So you don't mean those are not part of the JCE and only S21 is part of the JCE? Please consider this point. So based on the spirit, finally based on the spirit of Article 2 of the ECCCC law, the trial chamber has the jurisdiction to trial and prosecute the senior leaders of the Democratic Cambodia and those most responsible for the crimes and the grave breaches of both national and international laws. And Kaing, alias Duch, is not a senior leader of the Democratic Cambodia, nor the person most responsible for the crimes and the grave breaches of those laws. He is just a chief of prisons as others 195 chiefs of prisons who are not being prosecuted. Finally, I hope the court as well as the UN, and for the sake of the Cambodian people, before Duch is prosecuted as a scapegoat on behalf of those 195 chiefs of prisons, please consider this fact. Thank you.
I would like to ask whether Mr. Francois Rouge would like to respond to the opening statements by the co-prosecutors continued from Mr. Kasawut.
Mr. Ho, if the chamber were to decide to take a break now, I should be delighted, and perhaps I might be allowed to take the floor after the break. Thank you.
The President, in order to not be interrupted by the break, we should now we will resume at 5 minutes to 3.
Pardon, Monsieur le Président, merci.
Excuse me, Mr. President. The court that following the presentation of the opening statements of the co-lawyers, I would like to make a number of observations touching on the consequences or that might arise from these two statements. Thank you.
Please be seated. The President, the trial chamber would like to invite Mr. Francois Rouge to respond to the opening statements made by the co-prosecutor to be continued from Mr. Kasabut. You take the floor now.
Thank you, Mr. President. And Your Honors, as others before me, I am aware of the importance of this moment, which I might describe as historic. It is historic not only for Cambodia and the victims of the tragedy, but also for the international community and for international criminal justice, which in our turn we shall seek to buttress. This court here in Phnom Penh, which is hearing the Duch case, will contribute to the establishment of international criminal justice. The timeliness of this justice, or this justice which the news of what we hear around us reminds us that it is difficult. Today we have heard a head of state being indicted by the International Criminal Court, and this head of state is defiant in response to the International Criminal Court. He is in defiance of international judges. Here in Cambodia, Mr. President, Your Honors, as I stand here before you, I am pleased that in spite of all the difficulties, all the obstacles leading up to the creation of this court, I am pleased that today you are here. And so is Duch. He is sitting opposite you. The victims are here as civil parties, and they are represented by their lawyers. In and of itself, that is already worthy of note. I can only support, therefore, the communiqué issued by the Council of Ministers of the Kingdom of Cambodia, which on the 30th of March, which said on the 30th of March will be a new milestone on the road to the success of the extraordinary chambers in the courts of Cambodia, in trying Duch and the former Khmer Rouge leaders. The communiqué adds that it is successful, or it is a successful reflection of the partnership between the United Nations and the government of Cambodia. Cambodia is one of the member states of the United Nations. And it is because Cambodia agreed that we are here today. There is no difference between the national judges and the international judges sitting on the bench, nor is there any difference between national and international lawyers or the national and international co-prosecutor. In this courtroom, all we have is judges and officers of the court who are working to ensure that justice shall be done. Mr. President, Your Honors, the prosecutor, or should I say the co-prosecutors, in their opening statements, relied heavily in the material set out in the closing order, and you will observe that insofar as much of this material is concerned, Duch is in agreement. When further on into the case, we are going to deal with the admissions of facts by the accused, you will note that most of the facts, or the majority of the facts, which are included in the closing order are the subject of an agreement by the accused. So Mr. Robert Petty, when he was closing his address this morning, told you that, in fact, you will, at the end of these proceedings, you will render a decision to determine whether the admission of the crimes by the accused is really sincere and whether it is consistent with the duties that he actually carried out. That will indeed be one of the points that these public proceedings will elucidate. That is, what was the degree of autonomy or lack thereof of Duch in his duties as the head of S21. And when we come to that, we shall certainly hear experts. We have proposed some for the chamber. The Office of the Co-Prosecutors has proposed experts of its own. I should like to say here that, in my view, there was one major element lacking from the statements of the co-prosecutors, or better still, two. They did not allude to terror and secrecy. All the experts agree that this dictatorship operated on the basis of the twin pillars of terror and secrecy. It was because of the terror that every link in the chain of command acted zealously to please superiors, who were the ones who issued the orders. And this is the reason why Duch told you and told the co-investigating judges, "It is I who gave the orders to my subordinates. I assume responsibility." And I would tell you that not many people in this country today will accept that they themselves gave the orders. Does this mean, therefore, that we should cloak in silence the fact that he himself received orders? What we agree happened below him happened equally above him. But he says, "I received orders, I transmitted orders, I assume responsibility for the crimes." We shall certainly return to the issue of obeying orders, not as an exculpatory element, but since the Nuremberg trials, we shall consider this as a mitigating circumstance. My learned friend of the Office of the Co-Prosecutors would do well to refer to the article published on the 18th of March 2008 by Mr. Jacques Langteau in a Canadian newspaper on obedience of orders. So we heard the prosecutor, the Office of Co-Prosecutors, dwell on this, and my learned colleague and friend, Mr. Karsavut, also touched on the point. Once more, permit me to say publicly how much respect I have for Mr. Karsavut, a former prisoner of the Khmer Rouge, who defends them. He is a credit to the profession. Mr. Karsavut, in the beginning of the 80s, when he was a teacher, took his pupils to visit S21. Could he possibly imagine that one day he would find himself as a lawyer defending, representing the director of S21? But such is fate. And this fate is totally characteristic of what happened here. As he reminded you, because one of the co-prosecutors wished, only 5 people will be tried today. So Mr. Karsavut addressed the court, and he said, Please, do not make Duch the scapegoat of all that. And then you, or we, heard Duch address the court. I thank the Chamber for allowing this at this stage in the proceedings. You must believe me, Your Honours, that it is not easy to come here in public, in this courtroom, facing the victims and the public attending, to come thus and say, I recognize, I am ashamed of all I have done. Do you think that it is as simple as that? It is a long road to travel. It is a long, lonely road he has traveled for years. That is how I found him from our very first meeting. He said to me, I have recognized, I wish to acknowledge, I want to talk to the judges. I want to talk to the victims. With his agreement, we asked for a reenactment. For those who are not part of the civil law system, forgive me, reenactment in our system is a matter of course in legal proceedings. But in this specific case, it was a major proceeding